We have quite a few people joining now, so I might get started. So good morning, my name is Amanda Brissot. I am General Manager of the Western Sydney Business Connection. I'd like to welcome you to today's webinar, Bullying and Harassment in the Workplace, presented in partnership with our Platinum partner, Matthews Folbigg Lawyers. Before we commence, I would like to acknowledge the traditional owners of the land that we are meeting on today, wherever that may be for you. I'm on the land of the Darug and Guringai people. For over 60,000 years, the land that I am on was occupied by the Darug and Guringai and has never been ceded. I not only acknowledge them as the traditional owners of the land on which we meet, but also as the world's oldest surviving culture and their continuing connection to land, water and culture. I acknowledge any Aboriginal and Torres Strait Islander we have online today and to the elders past, present and emerging. Well, let's just jump straight into it. I'm delighted to introduce you to Peter Doman. Welcome, Peter.
Thank you, Amanda. Thank you for the introduction, and thank you for those introductory words, and welcome to country.
So Peter is a Senior Associate with Matthews Folbigg Lawyers, a proud Western Sydney University graduate. Peter specialises in a number of key areas of the law relating to business, including employment and workplace relations law, discrimination in employment, work health and safety. So we really appreciate Peter giving up his time and to share his knowledge with the WSBC community, as we know how busy you and the team at Matthews Folbigg are. Peter will be making a 30 or 35-minute presentation, and there'll be time for a Q&A at the end. So if you have questions, please just submit them using the Q&A function. You can use the chat function if you like, but the Q&A function is better. Now, we understand that we'll be covering some sensitive issues today, and some of your questions might be a little sensitive. So if you wish to remain anonymous, please just select the Send Anonymously tick box in the question component section of Zoom. So without further ado, please let me hand you over to Peter. Thanks, Peter.
Thank you, Amanda, and good morning to everyone attending today. I appreciate your time and attention. As Amanda said, I'll be discussing the perennial or evergreen issue of bullying and harassment in the workplace and the legal risks that you need to know. It seems like every third or fourth day we get inquiries about bullying and harassment, and it's one of those perpetually concerning issues to employers, and it has been expanding in focus over the last 10 years, and particularly since the introduction of the anti-bullying jurisdiction, the Fair Work Commission, which has given more legitimacy to bullying claims. It's become more and more in vogue. So today I want to cover the various aspects of bullying and harassment. We'll start off with some definitions, starting off at the ground floor, as it were. What is bullying, workplace bullying? What is workplace harassment? Where can we get some examples of what that constitutes, and so you know what to look out for. Then I'll cover some general forms of damages, legal risks, and the costs arising from workplace bullying, and that can be quite extensive, both from an economic and non-economic standpoint. Then I'll focus, the heart of my presentation will focus on what I consider to be the sword and the shield for employee protections against workplace bullying, and that is having a workplace bullying and harassment policy. And I'll go through what that policy should, or certainly must or should contain, and hopefully you can, if you've got your existing workplace bullying and harassment policy with you, you can see if it covers everything that we discuss. Then I'll look very briefly at the processes, or an appropriate process for investigating bullying and harassment complaints. Now, workplace investigation is an entirely separate field in itself, and I could speak on that separately for at least 2 hours. So that will be a very brief summary of investigations and the appropriate process. And then I'll finish off by the million-dollar question, which is what sort of disciplinary action can an employer take, and what are the risks arising from that? Can I dismiss? What else can I do when I find that bullying and harassment in the workplace has occurred? So without further ado, let's start with the concepts. What is workplace bullying and what is workplace harassment? We'll start with the first limb. What is workplace bullying? And anyone who's been around lawyers or interacted with lawyers for an extended period of time will probably appreciate that lawyers absolutely love definitions, and complex definitions and wordy definitions of that. For the purpose of my presentation, I'm going to be focusing on a definition contained within the Fair Work Act, and specifically at section 789FD of the Fair Work Act. And this was introduced a few years ago, about 7 or 8 years ago, when the anti-bullying jurisdiction was introduced. But there are some equivalent provisions in work health and safety legislation in various states and territories. But for our purposes today, I'm going to look at this definition, and it says, by way of three general limbs, a worker is bullied at work if, while the worker is at work in a constitutionally covered business, an individual or a group of individuals repeatedly behave unreasonably towards a worker or a group of workers, including a worker, and that behaviour creates a risk to health and safety. So that's quite a complex definition. Let's unpack that a bit. You can see that there's various tests and various thresholds and hoops to jump through. Firstly, there'll be a worker. The worker must be at work. That worker must be working at work in a constitutionally covered business. The worker must be subject to repeated behaviour, and that repeated behaviour must be unreasonable. And finally, that unreasonable repeated behaviour must cause a risk to health and safety. Let's take each of these in turn quickly. Firstly, what is a worker? Well, obviously a worker includes an employee. That should be fairly evident, but it expands, the Fair Work Act extends that definition beyond employees and covers things like contractors and more informal or nuanced relationships such as volunteers, outworkers, apprentices, labour hire employees. Because the concept of worker is so general, I would also certainly argue it covers directors of businesses who may not necessarily be employed by the company itself. So there can be bullying occurring at the director level as well. So keep that in mind. Next limb, what is at work? Well, this is not defined anywhere specifically in the Fair Work Act, but the expression at work is generally, we generally rely upon the expression as it's used and interpreted under the Work Health and Safety Act. And that, following a range of cases for claims under work health and safety laws, the concept of work has been interpreted very, very widely. It's not restricted to the workplace itself. It's also not restricted to the times that the employer is actively engaged in work. So it could include while an employee is at a client's premises. It could include when the employee is on the way to a client's premises, so driving the vehicle. That could be at work. And there have been cases that in a vehicle is a location that's subject to compensable workplace injuries. It could also be where an employee views social media posts whilst at work, but the posts themselves were made outside of working hours and outside the working location. So provided there's any form of nexus or connection between the workplace, you're probably going to satisfy this limb. Next, what is a constitutionally covered business? Well, that's a very wordy way of essentially saying any company, whether incorporated under the Corporations Act, incorporated in a territory, or the Commonwealth. It doesn't include state government departments, and it doesn't include local councils. But pretty much everyone else is captured by these laws. What is repeated behaviour? Well, it should be fairly evident what repeated behaviour is, but it's important to pause on it briefly. Under the Fair Work Act's bullying definition, a single instance of bullying, or what would commonly be considered bullying with its natural meaning, isn't actually bullying for the purpose of the workplace, for the Fair Work Act. So for it to be bullying and captured by the Fair Work Act, it has to be repeated behaviour. It doesn't need to be multiple or many or numerous, it just has to be more than one. What is important is that repeated behaviour must be unreasonable, and that's an objective test. It must be evident that from the standpoint of a reasonable person would, in all the circumstances, see the behaviour that's repeated as being unreasonable towards the person being bullied or allegedly bullied. Finally, that repeated unreasonable behaviour must create a risk to health and safety. There must be a causal link between the bullying conduct and a risk to health and safety. Now, it doesn't have to give rise to an actual danger to health and safety, but just a potential danger to health and safety. So if it's reasonably evident or foreseeable that the employee will suffer some psychological impacts, some form of stress and anxiety or a depressive condition due to bullying or harassment, then that would be sufficient to give rise to workplace bullying. So I've looked at a fairly complex set of criteria for bullying. Well, what's not workplace bullying? So we basically have to look at the other side of each of those conditions. Firstly, conduct that's not carried out at work or has any connection to work at all won't be workplace bullying. So if a bunch of colleagues within your business go to a social event or the pub, a hotel, anything like that, outside of working hours, unconnected with the workplace, not sanctioned or organised by the employer, and bullying occurs there, that's probably not going to be workplace bullying. as mentioned before, a single incident of misbehaviour does not give rise to a bullying claim. Conduct that does not give rise to a risk to health and safety does not constitute workplace bullying, although it's rare that because the nature of the risk must be foreseeable, not actual, it's probably going to be unlikely that you're going to be able to rely on that, the risk to health and safety exclusion. But what is important for employers is the concept of reasonableness, and both under the Fair Work Act's anti-bullying jurisdiction and under work health and safety laws and workers' compensation laws, it's made clear that reasonable management action conducted in a reasonable manner does not give rise to a bullying claim, or for that matter, a compensable workers' compensation injury claim. And the concept of reasonable management action arises in the context of what I consider vertical bullying, and I'll come back to that in a little while. So what are some examples of workplace bullying? We've looked at the definition. It's a very wordy, complex definition, and there's a few limbs to consider, but let's look at some examples. Now I've got a list here of some examples of workplace bullying, and it starts with the fairly obvious, typical examples of workplace bullying: the abusive behaviour, the offensive comments, the offensive language, complaints and criticisms, misinformation, those sort of things. But then it gets into more nuanced as you go down the line, and behaviour that an employer might consider to be reasonable may be interpreted by an employer to be bullying. So you may have to keep that in mind when, for example, you're subjecting employees to performance management or just generally managing or supervising employees. So changing deadlines may be reasonable from a business perspective, but the employee might interpret that to be bullying if it's done for an improper or bad faith reason. Denying access to information you might consider to be appropriate because it may be confidential information or commercially sensitive, but an employee might consider that to be bullying. And finally, changing work arrangements or rosters, refusing leave requests. They may be reasonable due to reasonable management, reasonable business grounds, but the employee might consider that to be bullying as well. One thing not listed in this list, or set out in this list, is performance management and disciplinary action. And obviously, you as an employer have an obligation to ensure that disciplinary action and performance management is conducted reasonably, but an employee might take a different view and argue that a course of conduct leading up to the performance management or disciplinary action all forms part of the one whole cause of bullying. So we've dealt with workplace bullying. Let's look very briefly at workplace harassment. Now, harassment doesn't have a statutory definition from a general standpoint, but it is referred to in several anti-discrimination laws. And the main one is obviously the Sex Discrimination Act. And Section 28A, which we'll look at in a moment, defines specifically what harassment is in the context of sexual harassment. And also in the Disability Discrimination Act, Section 35 refers to, but does not define harassment. In fact, there's no definition of harassment anywhere else in that the Disability Discrimination Act. So because these references to harassment arise in the context of discrimination laws, it's clear that the reason for the harassment renders the forms of harassment unlawful. Even if it's not specifically, even if harassment isn't specifically taken for a discriminatory reason or is not subject to a particularly discriminatory ground, because bullying is so wide, I would just simply argue that any form of harassment would likely constitute bullying, so it's captured. Before we move off, I'll just quickly provide you with the definition of sexual harassment within the context of the Sex Discrimination Act. And you'll see there's two limbs: that a person has sexually harassed another person if A, the person makes an unwelcome sexual advance or unwelcome request for sexual favours to the person harassed, or B, engages in other unwelcome conduct of a sexual nature in relation to the person harassed. That second limb, that limb B, is obviously quite wide and can capture forms of conduct such as propositioning an employee, sending or showing sexually explicit materials, or even sexually explicit comments or conduct. The definition also makes clear that it's an objective test, because it goes on to say that the reasonable person, having regard to all the circumstances, would have anticipated the possibility that the person harassed would be offended, humiliated, or intimidated. Those three words at the end are important because if the person subject to the harassment has responded in kind, you as the employer investigating a complaint of this may say that the person could not reasonably be offended, humiliated, or intimidated. And that is a bit of a tenuous argument, but if they're available if you need it. So we covered what is workplace bullying and what is workplace harassment. Let's look at briefly what are the risks, the damages arising from this sort of behaviour which is becoming more and more prevalent. Obviously, workplace bullying and harassment claims can cause significant impacts to businesses at the workplace level. It also has a wider impact to the economy at large. In 2011, the Australian Human Rights Commission issued a report into workplace bullying. And in that report, they estimated that bullying harassment claims cost employers up to $36 billion per year. Now, given that was back in 2011 and these claims appear to have become more and more common since then, I would certainly estimate that real value nowadays is a lot higher than 36 billion. Now, that estimate in the report factored in hidden costs, some more obvious, but some a little bit less obvious. Firstly, damages, so that the costs associated with having to pay out claims, the discrimination claims, bullying claims, settlement of employment disputes. Also, the cost associated with legal fees, so the cost of having to get legal advice, legal representation. And in the course of discrimination claims in, for example, the Federal Circuit Court or the Federal Court, those claims can be quite expensive. There's also the cost of the use of resources, having to investigate and take disciplinary action against employees engaging in bullying is a drain on employers' resources. It takes away managers, HR managers, from work that otherwise be able to do or should be doing, and having to focus quite a lot of time and energy on these investigations. There's also the use of leave and absenteeism. Obviously, if someone's being bullied, that could cause that employee or multiple employees subject to the bullying to want to be absent from the workplace and use either accrued leave or simply just not turn up. There's also the cost of dismissal and rehiring. For employees who have specific, who are required to have specific qualifications or training, rehiring people and retraining people up to the level of someone who left because of bullying or was otherwise fired because of engaging in bullying is quite a costly exercise. And finally, there's general drops to productivity associated with the morale impact. So it's quite a costly process all up. Let's look at breach of contract claims, other forms of damage and other legal claims that could arise due to bullying harassment. Obviously, are breach of contract claims. That's where an employee alleges that the employer's failure to investigate or prevent workplace bullying was a breach of either an express or implied term of their contract. There could be Fair Work Act claims, such as bullying claims, discrimination claims, workers' comp claims, as particularly psychological injury claims, and work health and safety complaints. And as I mentioned before, the type of risks and damages will depend largely on the nature of the bullying. There's either horizontal or vertical bullying, as I put it. But what do I mean by that? Well, let's start with horizontal bullying. That is typically the bullying and harassment occurring at the workplace level between co-workers, between colleagues. And the forms of the manifestation, that sort of bullying, is obviously risks of arguments or disputes. There could also be physical violence. There can be reductions to individual employee performance or workplace efficiency, where people don't want to go to work and are unmotivated to work. There can be breakdowns in workplace morale, not simply with people involved in the bullying and harassment, but other people watching that and seeing the effects of the workplace bullying. There could be increased use of employee leave and absenteeism, so where people simply don't turn up to work, take sick leave, take an annual leave to avoid being bullied. There can be serious health and safety risks, obviously those giving rise to workers' compensation claims, anxiety and depression, but also risks of self-harm and suicide. I know that about 7 or 8 years ago, I believe, it might have been longer than that, the Victorian Crimes Act was amended to actually make unlawful workplace bullying because of a suicide, an unfortunate suicide by a person subject to ongoing workplace bullying. So it is a real risk, it's a material risk. It's not unlawful. Failing to prevent workplace bullying in New South Wales isn't unlawful yet, but it may well be in the future. And of course, it can have some serious reputational damage on employer. There's also the cost of employee grievances, as I mentioned before, the time in having to investigate these things and take the appropriate disciplinary action. And the legal claims usually arising from horizontal bullying is typically workers' compensation claims, bullying claims or discrimination claims provided for one of those discriminatory reasons, whether it's age discrimination, racial discrimination, sex discrimination, disability discrimination. That's horizontal bullying. What is vertical bullying? Well, as you might expect, that's where the bullying, alleged bullying and harassment occurs between an employee and their manager. And that manager may be acting on their own volition, or they may be acting on behalf of you as the employer. So sometimes vertical bullying can give rise to an us and them mentality, that the employer is basically making a complaint about performance management being conducted on behalf of the employer. Well, what are the consequences of vertical bullying? Well, mainly, and most principally, is the employee considering that performance management is illegitimate in its entirety. They will fail to recognise and correct legitimate performance issues or behavioural issues. That has a flow-on effect too, that where other employees see this and see that the employee is able to take advantage of this claim, or the employer is at the mercy of a bullying claim, that will give rise to a loss in managerial authority. It'll also give rise to a breakdown in trust and confidence between the employer and the employee. And can also give rise to reputational damage. So an employer may complain, whether to other employees, to their friends and family, or on social media, that their manager or the employer generally are a pack of monsters. So there are various forms of damage that are not simply economic, arising from these forms of bullying. Again, the legal claims that can arise can be workers' compensation claims. Usually there will be a psychological claim, a mental injury claim, bullying claim, unfair dismissal claim, adverse action claim, and discrimination claims. And those last three forms of claim I'll deal with right at the end. So let's get to the heart of the matter. What can you do to try and minimise or avoid the risk of workplace bullying and harassment claims, or workplace bullying harassment occurring in the workplace altogether? Well, firstly, keep in mind that there's no way to completely avoid bullying and harassment from occurring. All you can do is try to ensure the environment is such that the likelihood of that sort of behaviour occurring is minimal, or is minimised as much as possible. In my view, the best way to do that is through a bullying and harassment policy. And that policy can be used both as a sword and a shield for you as the employer. Firstly, looking at it as a shield, a policy can ensure that employees are aware of and know what they're required to uphold in terms of certain standards of behaviour, their expectations. And it can also minimise the risk of bullying and harassment, where employees are told that if they engage in this sort of behaviour, that they'll be subject to disciplinary action. And so that is a general deterrent, especially if the policy sets out a zero tolerance on bullying and harassment, which in my view it should. So that's how you use a policy as a shield. But how about as a sword? Well, as I said, there's no way to completely eliminate the prospect of bullying and harassment in the workplace. But if and when it does occur, then the policy is also helpful, because it allows you to take disciplinary action against an employee who acts in breach of the policy, particularly if the policy itself sets out what action may be taken and sets out expressly that the employer considers that workplace bullying and harassment is either a serious misconduct or otherwise suggests that they have a zero tolerance for that sort of behaviour. And when that sort of behaviour is investigated and disciplinary action is taken in accordance with the policy, then that in itself minimises the risk of unfair dismissal claims, because you essentially are adhering to your own internal policies and procedures. So let's look at some general layout, the general layout of the contents of bullying and harassment policies. Firstly, I'll mention from the start that there's no prescribed form for a policy or procedure. There's no required length. You can put it in whatever form you consider appropriate. It could be in a two-page document. It could be a 15-page manual. So the form is less important and certainly less important than the content. So here I'll go through what I think policies and workplace policies should include to minimise the risk of bullying and harassment. Firstly, it should have an introductory clause. It should set out the purpose or the overview of the policy. It should make clear that the employer has a zero tolerance approach to bullying and harassment, and that the purpose of the policy is to ensure the harmonious behaviour in the workplace and to minimise the risk to health and safety. Next year, you should have a definitions clause. You should have certainly a definition of bullying, definition of harassment and sexual harassment as well, and discrimination. And I think that it's important to try and rely upon, I think it's important to rely upon and use the definitions found within the Fair Work Act, particularly because the Fair Work Act definition of bullying requires repeat behaviour. And so that essentially gives you an out where an employee alleges a one-off instance of bullying. You can actually say, well, it doesn't give rise to bullying, and we have we can investigate, but it's not actually captured by the policy and doesn't give rise to any liability for us. So include some definitions so employees know what they are, what's included and what's not included. Give some examples of each. And if you were to go on the Fair Work Ombudsman's or Fair Work Commission website, there is a large range of examples of workplace bullying that you can refer to or rely upon. But the list I included earlier in the presentation is also helpful. Then you should include some administrative clauses. So firstly, the application of the policy. Does it apply only to employees, or does it also apply to contractors and volunteers? And in my view, it should apply to everyone who works in the workplace. Secondly, when it comes to application coverage, does it also apply to any associated entities, any group companies, or if you have them, of course, or is it only to a specific entity and not other entities within a larger group? Include definitions beyond the definition I just mentioned. So include the definitions of worker, us, workplace, or disciplinary action, so you know who's being referred to it in the course of the policy. Include a clause dealing with variations that allows you, as the employer, to amend, replace, or withdraw any policy from time to time, and that doesn't give rise to any potential liability or any claim by the employee if a policy is amended. Finally, make clear that the policy does not impose contractual obligations on the employed, and that's important because a lot of times policy will set out and should set out a procedure for investigating complaints. And obviously you would want to follow that procedure as much as reasonably practicable in the context of investigating a bullying harassment claim. But what if you don't? If you don't follow the procedure you set out in your own policy, and you fail to say that the policy is not binding, then the employee can argue that the policy itself forms part of their contractual terms, and the failure to comply with the policy gives rise to a breach of contract. And there have been several cases that give rise to significant damages claims for employees who claim just that. So make sure not only the policy sets it out, but also the employment contract too. Next, you should look at the meat of the policy is the compliance clauses. What must an employee do? What must the worker do? Firstly, you have to make clear that they must comply with all aspects of the policy at all times. You should also make clear that employees must report all experienced or observed bullying and harassment to the employer. You should also make clear that employers must assist in any workplace investigations into bullying and harassment, and that's reasonable. You must ensure that employees maintain confidentiality over both the complaint itself, if they're the ones that make it, as well as any evidence if they're required to give evidence or give a statement or have a meeting with you as the employer in the course of investigation. They should keep confidential what they say in those meetings. You should also make clear that employers or workers must not engage in any retaliatory or victimisation behaviour, that is, not any behaviour in reprisal for bullying complaints being made either against them or someone they know or like, or against filing any false reports. So the misuse of the process itself can give rise to disciplinary action. And you should also make clear that if an employee is subject to bullying harassment that is unlawful, serious, such as physical abuse, they are welcome to and should report that sort of behaviour to the police. I'd also recommend that you specify the policy requires compliance simply beyond the workplace itself. So to the extent you don't have a social media policy, make sure that you include that bullying and harassment includes social media posts about your colleagues. The policy should also include some procedural clauses. So it should, at the first stage, outline or identify the person or the position to whom complaint should be made. That could be either the employee's immediate director, or it could be a named person, or it could be the HR manager. So the easiest one is to set out that complaints of bullying should be made to their immediate manager, unless the employee doesn't feel comfortable reporting that to the immediate manager, in which case it should be reported to a senior manager or HR or some other nominated person. The policy should also make clear or include an informal resolution process and encourage employees to try and resolve grievances informally where appropriate. That is, to speak directly with the person who's engaging in the bullying and harassment and ask them to stop. And if that doesn't work, or they choose not to do that, or if it's not appropriate, then that they may then proceed with a formal resolution process to make a formal complaint or lodge a formal grievance. When you set out any procedural clauses, so stages for investigating or lodging complaints or investigating complaints, ensure that those processes are compliant with any pre-existing grievance procedure you may have in place. If you already have a grievance procedure and that grievance procedure is sufficient to capture what you want to do with the bullying and harassment policy, you probably don't need to include it again here, because what you want to try and avoid or minimise is any inconsistency between policies, because that just gives rise to confusion and employers can capitalise on that confusion. I'd also strongly recommend that the policy require that employees or workers make a complaint internally before pursuing an external complaint, for example, a Fair Work Commission complaint of bullying. Now, keep in mind that that is not, you can't force an employee to do that. An employee has a legal right to make a workplace bullying complaint, but one of the questions asked of an applicant when they make a Fair Work Commission bullying claim is whether they have complied with any procedures or policies before they make the complaint. And if they say no, then the complaint may pause until that's been completed. So I would certainly mandate or require that workers make the internal complaint before proceeding to an external grievance or external complaint with the Fair Work Commission. Finally, I recommend you include various disciplinary clauses, and I'll get to why that's important in a moment. But you should set out what the potential range of disciplinary outcomes will be, and you should make clear that that could include a dismissal and even dismissal without notice. If you don't include dismissal as an outcome, then employees might say that they weren't expecting that to be the outcome, and that may give rise to an unfair dismissal claim. So certainly put employees on notice in the policy that one of the outcomes of breaching the policy and engaging in workplace bullying and harassment can be the dismissal or summary dismissal of their employment. Finally, and this links back to a point I made earlier, put employees on notice that they may be subject to criminal liability for serious forms of bullying and harassment, especially ones that give rise to that involve abuse, assault, or battery. And also put them on notice that certain forms of bullying and harassment can give rise to defamation risks. Also put them on notice of the potential for discrimination claims as well. So what else can you do? So that's what you should include in the policy. What else can you do? Well, firstly, you should follow up with the policy. Make sure the employees are aware of and have read the policy. And in that respect, I'd also recommend that if and when you make changes to the policy from time to time, that you communicate that those changes are being made, that you notify them of the variations made to the policy. And you could simply, at the basic end, simply say that the policy has been updated and here's where you can access it and read it. And we require every employee to read this most recent version of the policy. Or you can set out what the changes are. And that obviously involves some more work, but is more protective, because if an employee claims that they didn't know what was in the policy, not only do you have evidence that you've told them that it's been updated, but you actually told them what the changes are. So I think that would be a prudent option if it's reasonable, as long as you're not making wholesale rewrites to the policy. Any minor changes, the substance of those changes probably should be communicated. Beyond that, it's important to actually adhere to the policy yourself as much as possible. So ensure employees consistently comply with the policy. Don't enforce it strictly against one employee and let other forms of conduct, other forms of bullying and harassment occur unchecked or unresponded to. If you have a policy in place that imposes zero tolerance on bullying and harassment, but never actually take any action against bullying and harassment until all of a sudden against one particular employee, then they could argue that the disciplinary action taken was unfair or taken for unlawful reason. So make sure it's consistently followed and adhered to. You could also institute a code of conduct which sets out general standards of behaviour to the extent that the bullying and harassment policy doesn't already do that. And again, if you do institute a code of conduct, make sure that you apply that consistently and impartially. You could conduct regular training and workshops with staff, particularly if there's a history or a risk of bullying and harassment. So that's probably more likely to occur in blue-collar environments than white-collar environments, but it depends on the circumstances and the nature of the people involved in the workplace. You should also ensure that any management action, disciplinary action, is conducted fairly and without bias as much as possible. You don't want an employee to allege that a claim or investigation into bullying and harassment was taken against one person, but not another when there was multiple parties to the bullying. And they might say that it was taken because of a discriminatory or unlawful reason. But otherwise, at the very high level, you should continually monitor the workplace behaviour. Keep an eye on staff morale and the general organisational culture. Keeping a close eye on that will hopefully avoid the possibility of workplace harassment and bullying occurring in the first place. Let's assume that workplace bullying and harassment has occurred and there is a complaint made by an employee or a worker. Well, what can you do about that? What should you do about that? I'm going to go very briefly through a few steps in investigating and conducting investigation into bullying and harassment. As I said from the outset, this could be a separate presentation of itself. So keep in mind, this is very brief. If you're intending to conduct an investigation, I probably recommend getting some legal advice either at the outset to ensure that what you're proposing to do is appropriate and that any disciplinary action you intend to take before you take it doesn't have any substantial risks associated with it. Anyway, let's look at this procedure. Firstly, step one, you should identify the parties. That should be usually fairly easy to do. It might be that a single person has complained about another person, but it may be difficult where there's an anonymous report or an anonymous complaint, for example, in a suggestion box. You don't know who the complaint is made by or who it was about. Keep in mind that there may be multiple parties to bullying complaints. There might be multiple bullies, there might be multiple victims, and a complaint made may not name all of the bullies or all of the victims. So that's really the purpose of the investigation, is to look into that further. When you identify the parties, keep in mind the two forms of workplace bullying, either horizontal or vertical. If it's horizontal, your pool of potential parties to the investigation will be the employees. If it's vertical, you may be looking at managers, HR managers, supervisors, etc. Step two, and I think it's probably the most important one from a practical perspective, that's taking steps to avoid the bullying and harassment. Firstly, you should put the employee on notice that the employee who's the alleged bully of the allegations and issue relevant directions, i.e. stop behaving in certain forms of behaviour immediately. You should consider removing the parties to the complaint from the workplace. So obviously, I think it would be prudent to place the victim or victims on special paid leave. That leave should not be taken out of their accrued and untaken sick leave or annual leave. So special paid leave is essentially a fancy way of saying we will pay you to stay at home until the resolution of this investigation. You could also suspend the accused on pay. Make sure it's on pay unless you have an express contractual right not to do that in either contract or enterprise agreement. That's probably unlikely. So usually you'll need to pay the accused to stay at home while the investigation is being conducted. But I recommend that be done, especially if the allegations are serious. Whatever you do, make sure you do it quickly. Don't delay, because waiting to act can exacerbate the bullying being undertaken or being conducted and increase the risk to health and safety. But beyond that, delaying may actually prevent or limit you from being able to dismiss an employee for serious misconduct. And if you do that, it may give rise to a right of the employee to complain or make a complaint of unfair dismissal, because they're essentially alleging that if the conduct was so grievous, then why did they not take the action earlier? So just keep an eye on taking action. Any disciplinary action, any investigation should be conducted promptly. Don't wait too long before actioning it. Next, you should prepare for the investigation, and that involves doing some homework, doing some paperwork, formulate and summarise the allegations. It may not be apparent from a written complaint or a verbal complaint what the allegations are, but so try and summarise them best you can, whether by chronology, in a chronological order or in a conceptual or heading order. Plan how the investigation will proceed, so who the witnesses will be, how they'll be interviewed and in what order. Consider whether you should have an external investigator conducting it. And that's will be especially important for vertical bullying. If the alleged bully is a senior manager or the person who would otherwise have engaged in the sort of investigation into the bullying, then certainly it'd be appropriate to have an external investigation conducted. And if that occurs, A, we can assist with engaging that investigator, and B, we can ensure that any correspondence between the investigator, ourselves, and the you as the employer are subject to legal professional privilege. So that's a valuable protection to have. Assuming you're going to be conducting an investigation yourself, you'll need to collate all relevant documentary evidence, including the complaint itself, any relevant correspondence, and any CCTV footage, if that's applicable. Send a formal notice to the accused setting out the allegations, so that relates back to the summary of the allegations. Send out interview requests to all relevant witnesses, and ensure the process generally complies with any policy or procedure you have, whether in the bullying and harassment policy or any other workplace investigations policy you may have in place. And finally, step 4, conduct the actual investigation. Now, although in the last slide I set out what you should do in terms of planning, there's no right way or wrong way of conducting investigations. So however it's conducted, however long it takes, whatever process you follow, whether it's in person, in writing, via Zoom, any other system, any other process, really you should just follow these guidelines. Firstly, ensure that it's transparent. Make sure that all aspects of the process are thoroughly documented. Make sure the process is objective and not predetermined. So in other words, let the accused speak, let them tell their side of the story. Make sure the investigations are conducted in a procedurally fair way, so that the employee who's the subject to the bullying allegations has a right to reply, has the right to know what the allegations are, has time to prepare their response, and if they want to attend any meetings with a support person, they can do so. It goes without saying to make sure that the investigation is not conducted by the accused bullying, particularly in vertical bullying, and make sure the investigation is not conducted in a way that will injure or prejudice the victim or the accused. And finally, as a general recommendation, ensure that everything's documented. All file notes are taken of interviews. If you get permission to record interviews, in New South Wales, you need to get the permission of all parties to a recording to consent to that recording. But if you can do that, then certainly keep them on file, because you may need them later on down the line. Finally, let's assume that workplace bullying and harassment has occurred. Let's assume that you've investigated that workplace bullying and harassment. And let's say that you have found that employees engaged in serious bullying and harassment in contravention of your policy. So what can you do about that? Obviously, the disciplinary action available to you is to dismiss the employee. And if the bullying and harassment is serious, that will be certainly an appropriate step to take. But don't assume that's the only step that you can take. You can take other forms of disciplinary action below or that are less serious than dismissal. And the range of action that can be taken is set out here. Firstly, you conduct workplace training, whether that's internal training or external training. You can implement a performance management process, a PIP or a conduct management process. You can issue a verbal warning or a caution. I tend not to like verbal warnings. I think everything should be documented. So even though you could basically tell an employee to pull their head in and not do it again, I think it's more appropriate to proceed to a written warning if that's what you're going to do. If you believe the conduct engaged in and the bullying harassment is serious enough to warrant a warning, but not serious enough to warrant dismissal, particularly in circumstances where you've indicated a zero approach to bullying, then I recommend proceeding straight to a first and final warning. A lot of employees still under the misunderstanding that there's some sort of 3 strikes requirement for warnings and dismissals. That doesn't exist anymore in the Fair Work Act. So if conduct that warrants a warning is sufficiently serious, that it's on that line between warning and dismissal, then I'd certainly recommend issuing a first and final warning. And then finally, you've got dismissal. If the conduct is of a kind that is renders the employee's ongoing employment untenable, that's certainly what you should do. And don't be afraid of making that decision. Now, over the last few weeks, I've had a few inquiries from some of our employer clients about the prospect of conducting without prejudice or off-the-record discussions with employees who are engaging in inappropriate behaviour. Now, you can do this, but it is an inherently risky thing to do. It has to be conducted sensitively and appropriately. You should make sure the employee agrees to having those sort of discussions off the record. Bear in mind that if you want to put a without prejudice settlement offer to an employee to just indicate that essentially we have these concerns, if they aren't addressed, then it's probably going to result in dismissal, but here's an option for both parties to hold their heads up high and walk away. Some employees are receptive to that. Some employees may be engaging in bullying harassment because they're dissatisfied with their situation at work and might jump at that. Some employees might find that offensive or batten down the hatches, as it were, and then you've essentially betrayed to a certain degree your position, your intention to dismiss them. So be careful about those without prejudice discussions. Have regard to the employee's personality and their sensibilities before you do that. Let's assume that you have made the decision to dismiss an employee. There are various risks arising from dismissal, and so I'm going to go through the main three now, so you know what to do to avoid those risks, or at least minimise those risks. Firstly, when an employee is engaged in bullying harassment and you decide to terminate employment, you need to give them written notice of written notice of termination. That applies unless they're casuals, and the Fair Work Act makes clear that written notice of termination cannot be before the day the termination is to take effect. So in other words, you should give them written notice on the day or when it's going to occur in the future. You can't say we terminated your employment last week, for example. You should make clear in the written termination letter that the dismissal was based on the findings of bullying and harassment. I would strongly recommend in any termination letter to set out the reasons. I know that some employers like to avoid doing that because it causes further anxiety or antagonism. But I think to avoid what I'm going to refer to in a minute as a general protections claim, to avoid those sort of claims, I think the reason for dismissal is important to be included. So you get it on the record. That's the reason you're relying upon. Finally, where you've made a decision to dismiss someone, but it's not serious misconduct, then I'd certainly strongly recommend you pay them in lieu of notice, provide them with pay in lieu of notice. Just get them out of the workplace as soon as possible. You don't want them hanging around if they've been engaging in bullying. Finally, if the dismissal is based on serious misconduct, so the bullying and harassment is of a kind that is so serious that would justify a finding of serious misconduct, then obviously the employee is not entitled to notice of termination or payment in lieu. The employee is still entitled to annual leave, whatever's been accrued and not taken out to the termination date. But bear in mind that certain states and territories have rules relating to whether long service leave is payable based on the employee's length of service. Now, very briefly, in New South Wales, when an employee has been employed for more than 5 years but less than 10 years, then if they're dismissed for serious and willful misconduct, and that's the expression, serious and willful misconduct, then they're not entitled to pro-rata long service leave that they would otherwise have received upon termination. Again, that's only between 5 and 10. In New South Wales, if they hit the 10-year anniversary, then essentially the long service leave is in the bank. They're entitled to it as of right upon termination. Now, if you provide notice of termination in writing and either give the notice or provide pay in lieu, then there's no risk of a breach of contract claim. What other claims can there be? Well, there can be unfair dismissal claims, and that's the most common type of claim brought when employees feel they've been hardly done by dismissal. So unfair dismissal is essentially a protection under the Fair Work Act where an employee claims they were dismissed in circumstances which is harsh, unjust, or unreasonable. And what do I mean by that? I mean that looking at it in reverse order, because it's the easiest way to understand it. Firstly, if it's unreasonable, there's no valid reason for the dismissal. If it's unjust, where the employee was not afforded appropriate procedural fairness, and that's why it's important to undertake that investigation. And thirdly, an unfair dismissal is where the dismissal was harsh, where the decision to dismiss the employee was excessive in the circumstances. In other words, did the punishment fit the crime? Now, to ensure that bullying, to ensure that, or to minimise the risk of an unfair dismissal claim, even if you conduct the investigation, you should still conduct a separate, appropriate and fair disciplinary process. So that might mean putting them on notice of the findings, giving them an opportunity to respond to the findings, have meetings with support person present, anything like that. Provide them an opportunity to show cause. And I certainly recommend the use of show cause as a final step before dismissal, because it's that final opportunity to respond. It's just that final step to provide procedural fairness, and it minimises that unfair dismissal risk. And finally, what other actions or remedies can an employee take? Well, the other one is what's called a general protections claim or an adverse action claim. And essentially the general protections protect an employee from adverse action taken for prohibited reason. Now that means, when I'm talking about adverse action, that means dismissal, demotion, prejudicial alteration of position, injuring them to employment or discrimination. So in other words, if you dismiss someone for bullying and harassment, that's clearly adverse action. If you demote someone because of bullying and harassment, that's also adverse action. But it's important to, the adverse action is only unlawful if it's taken for a prohibited reason. And one of those prohibited reasons includes where an employee exercises a workplace right. If an employee complains about bullying, but it turns out they were one of the bullies, then they may say that they weren't bullied, they weren't dismissed because of the bullying behaviour, they were dismissed because of the complaint they made, which was the exercise of the workplace right. So be alive to that potential risk. Any adverse action taken because of a bullying complaint, because they commenced a bullying application, will be obviously in contravention to the general protections. Those are more serious claims than unfair dismissal claims. They're dealt with in the court because they're findings of unlawfulness. So for this reason, before any dismissal is, any decision to dismiss is made or finalised, I'd certainly recommend that you consult with us or any other lawyer you have a relationship with, just to make sure that the decision to dismiss is associated with a minimal risk of these sort of claims. So I know I've run over a bit over. That's my presentation. I hope everyone got some useful information out of it. There's a lot to cover and there's a lot more I could have said. I hope that the running through the recommended or the essential contents of a bullying and harassment policy was helpful for those following along and cross-referencing what they have in their policies, their existing policies. However, as a special offer for WSBC members and those viewing, we'd be very pleased to offer anyone who's interested a free bullying and harassment policy checklist that basically sets out in more detail than what I've done today, what a workplace bullying and harassment policy should or must contain. And so you can ensure that your existing policies are as protective and as compliant as reasonably practicable. So if anyone wants that copy of that policy checklist, please contact me after this presentation, and we'll probably be sending them out in the next few days. So that's my presentation. Let's go back to some questions if anyone has them.
Great. Well, thank you for that it was very detailed and very informative presentation, Peter. Really appreciate that. We do have a couple of quick questions. Just quickly, there is one. Are you able to share the slides? I know we're sharing the recording, but are you happy to share the slides?
Yes, of course. So if anyone who wants the slides or wants the slides plus the checklist, just contact me after the presentation and I'll probably send them out in the next few days.
Great. And also, is there some type of checklist to be good access? There you go. We already talked about that. Where is the boundary between bullying, harassment and personality differences?
That's a good question. It really depends on the circumstances, the personalities involved and the nature of the workplace. There have been cases where comments that would ordinarily in a white collar environment be certainly inappropriate. So swearing, using the F word, calling people effing C's, that sort of case, that sort of situation, that's found to have not been inappropriate or excessive given the nature of the workplace, for example, in the context of a truck yard. So it depends on the nature of the circumstance, but you really need to go look back at the thresholds and the tests for what is bullying. Is it unreasonable behaviour? Is it repeated behaviour? And is it behaviour that it's on the circumstances likely to cause a risk to health and safety? And that should be your guiding light. Is the sort of behaviour likely to cause a risk to that person's health and safety and cause offence, stress, anxiety, a psychological condition, some other mental issue. Harassment and discrimination. You're looking at the same question, but also looking at whether it's based on a particular discriminatory reason. Was the bullying and harassment taken because of the person's disability, if they have one, or alleged disability, their age, their gender, their sexual orientation, their race? That sort of behaviour is not only bullying, but it's also harassment and discrimination. And so that increases the severity of the bullying to an extra higher unlawful level. But the takeaway is consider all the circumstances, consider the nature of the workplace, consider the personalities and the sensibilities of the people involved. Sometimes it's just a judgment process. But if anyone comes to you complaining they've been bullied and harassed, you should necessarily assume that they're legitimate, they're genuine complaints.
Yeah, it's interesting, isn't it? I think there are some managers that might be a little more direct and forthright in the way they communicate, and they might have some employees that are a little bit more sensitive, and that might, you know, sometimes be perceived. So yeah, there's lots of grey area in there. So I think it's important to be really clear about what is and what isn't, and also really clear about what your steps are to manage it.
Well, that's right. And just touching on that a little bit further, because what you mentioned there just raises the issue of vertical bullying, when an employee alleges that performance management or aggressive supervision by a manager, or robust supervision by a manager, constitutes bullying. Obviously that manager is likely to dispute that or challenge that. And so as long as you, keep an eye on the management style, keep an eye on what's conducted, the sort of behaviour that's engaged in during performance management meetings, and ensure that any performance management process is formal, unbiased and neutral, and comply with any performance management policy you have in place. That is going to minimise the risk of employees making those complaints that performance management was itself bullying.
Another one here, what if they don't report a complaint but feel bullied and harassed? I guess that means, you know, if they've sort of said that, you know, I'm feeling bullied and harassed, but haven't actually made a formal complaint. What's your advice there?
Well, your obligation is to avoid bullying occurring in the workplace, and that obligation arises both under the Fair Work Act and also arises under work health and safety legislation, workers' compensation legislation. So the mere absence of a complaint does not mean you're relieved of any obligation to avoid those, to ensure that workplace bullying and harassment doesn't take place. So if you see it occurring, or you reasonably suspect it is occurring, then you should still take the appropriate action. That action may be less formal or less rigid than conducting the investigation that you would need to undertake if there was a formal complaint made. But if you see it occurring, and if you have a bullying and harassment policy that sets out zero tolerance to that sort of behaviour, then certainly you should address it formally through a disciplinary process, either through a first and final warning, dismissal, verbal cautions, training, whatever it happens to be. So don't assume that the absence of a warning gets you off scot-free, because it won't. And
one very quick one last up. So if you do make the complaints to, you know, HR or to your senior managers or whoever, and it's not acted upon, what's your advice there?
Well, that question is, I assume, made, and thank you for the question who posed that question. If that question's coming from the standpoint of the employee, yes, that employee presumably would be able to. Well, it depends on the circumstances and the nature of it depends on several factors. If there was a contractual obligation to comply with policies, which again, we as advising employees would recommend not arise, but if there was a contractual obligation to comply with policy, that might be a breach of contract. The employee would certainly have a bullying and harassment, a bullying claim in the Fair Work Commission that they could bring. If it's taken for discriminatory reasons, there may be a discrimination claim. If the bullying and harassment occurs following the employee's exercise of workplace rights, which is actually quite common, that employees allege they were being bullied because they took leave, because they're absent because of an illness, because they complained about their supervisor, and then the bullying occurred after that, they would have general protections claims or adverse action claims. So So there's a range of remedies available to employees that are pretty much external legal claims and remedies. Obviously, if an employer is refusing to investigate a complaint, then going back and complaining about the failure to investigate is probably not going to have much value. So employees do have some remedies. Unfortunately, they're all external, they're all quite formal, and they usually do involve some effort or legal costs. So there is that risk there.
Hopefully it won't come to that. So I think that's all we have time for. We have run a little bit over. There's plenty of requests for a copy of the checklist and the presentation. So that's great. I'll just let you all know that we will be sending out a copy of the webinar and the presentation in a letter to you in the next little while. So just keep an eye on your inbox for those. And please feel free to contact Peter directly. We'll share his contact details as well in that letter that we send out to you shortly.